In the European continental countries, the legal system has traditionally three layers of meaning. It means that the full meaning of the legal determination on the situation of social life is distributed in the three layers of law. The text of legislative acts gives some prescriptions for the conduct of individual, but the full meaning of these prescriptions is understandable only through taking the categories of legal dogmatics, which are only signalized in the text of the legislative acts, but they are to be found in studies and commentaries isolated from the legislative acts. The text of the prescriptions of the legislative acts and the more comprehensive studies of legal dogmatics are two different layers of the law, but they are not enough. Namely, the text of the legislative act built on legal dogmatics has an open-ended nature. Backing by the legal dogmatics, the law became systematized in the European continental countries in the 19th century, but the abstract codified law became open-ended. On the ground of the open-ended legal prescriptions, the judges could decide in quite different ways in the same situation. For the legality, it was unsupportable, this situation. That was the reason that, although the judge-made law became illegal in these countries, step by step the highest court developed a third layer of law, which always specifies the abstract codex prescriptions in a more detailed fashion for each situation. In the first half of the 20th century, this picture outlined perfectly the real function of the legal system in the European continental countries. The full meaning of the legal determination was contained in three layers of law: the layer of the text of the legislative acts, the layer of the legal dogmatics, and the specified layer of the precedents of the higher courts. This picture was real for the law in Germany and in the East European countries, influenced by the German law first of all. But with some modification, this multi-layered nature of the legal system was true in the whole European continent. The English law remained an exception because in England the codification of law didn't happen in the 19th and 20th centuries, and in this way the English legal system has only one layer which contains the full meaning of legal determination for the conduct of the individuals. And this is the precedent of the common law. Added to this, the extremely specified prescription of the statutes, which is the last century has grown in a rapid way. It is important to note that after the secession, the new United States has retained the English common law, but in the 20th century some codification happened in this legal system, and to a certain degree the American legal system can be characterized as a halfway between the law of England and the European continental law. In this way, the multi-layer structure of law is to be seen in the United States to a certain degree. But there was a great transformation of the law in the United States of America beginning from the 1960s, and the constitutional rights came to the front of the law. It was the rights revolution, as was named this transformation. The text of the legislative acts and the argumentation on the ground of the basis of legal dogmatics lost their importance, and the full legal determination of the situation of the social lives was contained by the argumentation of the constitutional rights. Taking that seriously, said Ronald Dworkin in 1975, but really he emphasized that only the constitutional rights and the specified decision of them by the Supreme Court have to be taken seriously, and the other layers of law were pushed into the background. Backing by the world power of the United States and the extensive efforts of the exportation of the American cultural and ideological values, this transformation of the law appeared in the European continent too. In Western Europe, the rights revolution had some effects on the legal system, and where a constitutional court was institutionalized after the Second World War, the constitutional rights as a new layer of law developed step by step. These countries were the occupied countries by the American after the Second World War, Germany and Italy. But after the breakdown of the dictatorship in Portugal and in Spain, the Constitutional Court and the new layers of law appeared in this country too, in these countries too. And after the breakdown of the Soviet Empire, the new East European democracies introduced a model of the strong Constitutional Court. This new layer of law transformed the weight of the older layers of law, and the importance of the text of legislative acts and the legal dogmatics diminished, and the argumentation from the constitutional right came to the front. And where an activist constitutional court could dominate the legal system, the most important layer of law became this new layer. This phenomenon could be seen in Germany from the beginning, and after the breakdown of communists, Hungary institutionalized a very strong constitutional court among the new East European democracies. But in this respect, I'd like to make a difference. The effects of the layer of constitutional right and the constitutional court can appear on two levels. On the legislative area, the constitutional rights have a great impact in Germany and in all countries where there is a constitutional court. The earlier decisions of the Constitutional Court contain already the chief aspects of the future legislative acts, and the Constitutional Courts control the new legislative acts continuously. And where there were a very activist constitutional court, as in Germany and in Hungary, the legislation functioned in a subordinated fashion to the constitutional court. The other area of law is the judiciary, and it is a question how strong the functioning of the judiciary is determined by the decisions of the constitutional court and the constitutional rights. In Hungary, for example, the legislation is subordinated to the Constitutional Court, very strong, perhaps it is the strongest in the world, but the judiciary has an autonomous position. Here the judges decide on the basis of the text of the legislative acts, and on the ground of the argumentation of the legal dogmatics, but not on the ground of the constitutional rights. It is said that the legislative acts were already controlled by the constitutional rights and the constitutional court, and if there were not annulled, these legislative acts contain implicit the constitutional rights, and in this way there is no necessity to listen to the argumentation and arguments of the constitutional court. Of course, there are a great battle in this respect among the groups of lawyers and rights activists in Hungary, but the mainstream of lawyers resist, and it is said that in respect of the legislation, the strongest constitutional court in the world exists already in Hungary. And it would be dangerous if this strong constitutional court could control the thousands of decisions of the judiciary too. In the end, I can summarize my short lecture. In the last decades, the multi-layer picture of the law was transformed in the European continental countries, and recently there are already 4 layers of law which the full meaning of the legal determination contain. The layer of the constitutional right is at the top of the law. The text layer of the legislative acts is formed always within the framework of the top layer, and the layer of the legal dogmatics, and lastly, the specifying precedents of the high courts give the lowest layer of the law.